All right. Well, I think we all know each other. I'm Emily. Thank you guys for coming out. And like Ben said, we just like to host these events, small group events every once in a while through the year here at the Price Group, to be able to, obviously at the Price Group, we love to be your resource for anything about real estate. And real estate has so many kind of what I call it sisterhood little arms and legs and branches off of it that when within our company we think about genuinely wanting to be full service for our clients, then we also want to take care of all of the other things too. And so with I think most of you know Ben. This is my business partner Brad. So some of you probably know him as well. Very instrumental part of the Price Group organization. And so tonight what we're doing is we just thought we would take care of something that is high on everyone's list of fun and excitement, and like we couldn't think of anything else to talk about on a Thursday night.
Talk about death.
Wills.
Oh, similar.
Legacy.
It's almost Halloween.
Legacy.
Yes.
Yeah. Okay.
How about how you couch it?
So we're gonna package that a little bit differently. All right. So we thought what we would do is, this is Cora and Morgan, two of my personal favorite attorneys in the whole city. I trust them very, very much, and they take great care of our clients. And so Cora and Morgan are with Pitt and Frank. I think a lot of you guys are familiar and have probably been there with me before. And so they also are great. Not only are they great experts with all things real estate law, they also really know their stuff when it comes to wills and trusts and real estate planning. So what we're going to do this evening is I'm going to ask them, we're going to have kind of a Q&A session. I'm going to ask them questions that I'm imagining that everyone has, okay? And then and they're going to just, share their wealth of knowledge with us. And then we're going to open up the floor for any questions you guys have, so that the intention is that you can come out of this evening with some more knowledge. A will or a trust, they're going to tell us the difference. It's something we all need to have taken care of anyway. And then also so that you can leave tonight with a path forward of how you can get it taken care of easily. So you can check that off your list if that's something you're looking to do. Cora did my will. It is super easy. She also did my parents and my grandmother's. So it's super easy and it's not scary, and she makes it simple. So, all right, Cora, I'm going to let you introduce yourself for anything I didn't share, and then Morgan, you as well.
Well, hello, lovely folks. My name is Cora Henderson, and of course, Morgan, I'll let him introduce himself as well, but we are both attorneys here with Pitt and Frank in town. And what I love how Emily teed us up is, yes, we're primarily based in real estate, right? As is Emily, and real estate includes both residential and commercial real estate transactions and closings and investments. But, oftentimes it involves so much more than just the real estate. We want to look at liability protection, whether that's business law planning. We want to look at preserving your assets. We also want to look at estate planning. So many times when we have the real estate purchase, whether it's a primary residence or a rental, it can oftentimes be the biggest investment you'll ever make in your life. So how do you leave that legacy? How do you plan ahead of time so that your children don't fight when you're gone? How do you make sure, as best as you can, that there's a little bit of peace and continuity? And also at people's top of mind, and we'll kind of unpack this, is how do I pay the least amount as taxes legally, and what is the smoothest, most efficient process so that while I leave grieving loved ones behind, because we're never promised tomorrow, what's the best path forward on that? So even though we're primarily based in real estate, I can promise you that that also touches other more full service areas, including estate planning, which we also specialize in with wills, trusts, powers of attorneys, and other similar types of conversation. And I also mentioned, of course, business planning. We handle 1031 exchanges. And again, that's that full service piece of basically anytime you have a real estate investment, there may be those spider webs that kind of come out and touch other areas of law and other types of planning that we can assist you with. So again, I'm Cora Henderson. I've had the privilege of working at Pitt and Frank for 15 years, but I've been practicing for over 20. Got my law school reunion invitation the other day. I am a Cardinal Louisville native through and through. Fun fact, I used to know this gal when we used to dance together growing up as wee littles, right? And she knows this. I've told her this not to make her blush, but I idolized her in middle school as she was my dance team captain. So I was kind of younger. She was kind of my older mentor, and I still admire her to this day. So I'm so happy and grateful to be here. Oh, you've got your own mic.
I do have. I'm Morgan Denors. I'm also an attorney at Pitt and Frank. That's also really hard to follow up. So thank you for that. I'm obviously the beauty of the panel. But yeah, I think as we kind of go over the bits and pieces of wills and trusts, if there's anything that we don't get on today, we're always available to ask questions later. So, and if you just want to talk, or if it's wills, trusts, and the other pieces like the business planning and so on and so forth, we can obviously cover that too.
Awesome. Well, let's dive in. You ready?
Absolutely.
Okay, so my first question, I've got my cheat sheet here for you. My first question for you is, why do I need a will, and what steps should I take to get one in place?
You're okay. No, I can take it. I think the main reason you need a will, and it kind of goes into the process of home buying, and kind of like Cora touched on in her opening statement, you know, buying a house is usually the biggest investment that anyone makes. And whenever you don't have a will, those assets that you've taken your hard-earned money and put into, the government kind of gets to sort out where your stuff goes, whereas with a will, it's totally up to you. And it does alleviate a lot of the problems of, you know, different people in the family want different things. And again, if the government gets to choose, it may not be what you had envisioned when you had thought about passing down your money, your hard-earned assets. So I think a will is really the key piece to just ensuring that your wishes are carried out, and obviously making sure that, you know, no one fights over it at the end of the day as well. So I think that's the major piece as to the why. As to the how, it's really just calling us. We're more than happy to talk to you. We don't charge by the hour. We just kind of like to listen to what your needs are. As far as what you want to get out of estate planning, where you want those things to go, how you want them distributed. And you can really get as specific or as general as you'd like to be. So we can be very nuanced, we can be very specific about, you know, heirlooms in the family or what have you, or we can be very general. And that just, we want to make sure that we're doing right by you. So ultimately it just starts with the conversation, and then it goes back and forth with paperwork and just making sure that everything is done correctly, and then eventually it's signing. And it really is an easy process. It doesn't take too long. It doesn't take a whole lot of effort. And oftentimes after having that initial conversation or consultation, there may be things that come up that you never thought about. Or we'll ask questions that you kind of go, hey, you know, I'm not sure what I want to have done with that particular piece of my estate. So that initial conversation can help generate some of those questions that may make it a little bit easier down the road once we actually put pen to paper at the end of the day.
Absolutely. The only thing I'll have to add to it, and you did a really good job, Morgan, by the way.
Thank you.
Would just be, I know this sounds a little bit morbid, and anytime we talk about death, it's a wee bit morbid, although we're approaching on Halloween. But let's all think about funerals, okay? Are funerals for the dead? She's shaking her head no, guys, at home on YouTube, whatever the case may be. What are the funerals for? Family. They're for the living. I would ask you to approach the same thing about wills. It's almost selfless, if you will. So your will and your estate planning, it isn't about you. It isn't about your death. It's about protecting and planning for the living that you leave behind, just like your funeral arrangements do. And so really come from that selfless approach. I know it's a little bit morbid to think about our own mortality or when our day is up, and we never know when that is. But really just taking that humble approach of saying, I am going to take this step, as uncomfortable as it may be or as young as I may be, and I'm going to do it for the loved ones that I am leaving behind, because it does help resolve or limit to the best. I mean, it's not always imperfect, but some conflict. It provides for necessary planning as far as your different allocations, and you can try to minimize some tax objectives and really simplify and make it a little bit more efficient as it relates to the probate process. Your other alternative, as Morgan indicated, would be leaving it up to, Kentucky's intestacy scheme, or maybe even other states, depending on where you're domiciled at. And that tends to be a little bit more of the unknown. And I don't know about you, but I tend to like to control things. And if that involves me controlling my wishes through my own will for the benefit of my loved ones that I'm leaving behind, I'm going to do it.
Okay, so what's the difference between a will and a trust? And how do I know which one I need based upon the type of property I have?
I started the last one, so.
Oh, all right. Well, I'll totally bite. So they're totally irrespective of one another. So your will is your last will and testament. So that's going to account for, in a simplified manner, who you want to carry out those wishes. Who do you nominate to be your personal representative? Who do you nominate to be your fiduciary to carry out your estate and those wishes pursuant to your will after your death? Who's going to advocate for you? Who's going to make sure this is done in this method? And that's why we tend to allocate certain family members in that position, because if you nominate somebody you don't know real well, that's quite the burden to carry on. So in addition to that, you're also specifying, whether it be personal property and heirlooms, as Morgan touched on, your real property, maybe specific devices and bequests and gifts, but ultimately who you want your beneficiaries to be or not to be. And so that can be specified in your will, make specific gifts. Maybe you want your wedding ring to go to a certain person. Maybe you want everything to be distributed and broken up evenly amongst all your children to share and share alike. There's a number of different ways that we can provide those estate planning tools, wherever it be generalized or even down to the detail, so that you feel most comfortable about that. I think the differences between a will and a trust, everybody should have a will, because why not? I don't care what your age is. It doesn't hurt anything. It only would arguably help that, because otherwise, as we'll talk about in a moment, you'd be subject to the intestacy laws. That's a little bit of the unknown, lesser control. But a trust, alternatively, is a different type of contractual agreement. It is a trust instrument. It's a contractual trust instrument that can accomplish a number of different things based on your estate planning needs. But a trust itself, while you may pay a lot of money for it, it may come in the fanciest leather binder you've ever seen, depending on where you go. It's only as good as how much that you fund that trust, whether it be certain vehicles, trusts, assets, real property, things of that nature. That's what it could be useful for. If you don't fund it, if you don't title anything in the name of the trust, well, then it just becomes a fancy piece of paper. But why do people oftentimes do trust, at least for the right reasons? I think a lot of it is anonymity, confidentiality. Those are private trust documents. A will isn't recorded, isn't admitted to probate until your estate's open, which you're dead, but you don't record that in advance, okay? But technically, when your estate is open and that will is probated, it does become public record. So people do see those wishes being published, so to speak, whereas a trust is never recorded. There is no public record. It is a private document. So some people enjoy that anonymity and confidentiality. It can also provide an incredible amount of flexibility for you to plan for your beneficiaries, because really the trust is set up for the benefit of your beneficiaries. Now, you might be the beneficiary, or your heirs, or your children, or whoever you designate. There can also be a number of different reasons why you set up a trust, such as there's land trusts for different types of real estate investments that may be separate and distinct from revocable trusts, which may be more living trusts that are probably far more common. There are testamentary trusts, which are kind of pour over provisions in your will. Let's say if you have minor children, but you don't have a trust document yet, but if you die whilst your children are still minors, you will have a trust created at that time. It's a pour over provision in your will. It's a testamentary trust provision, so that trust can be set up to hold those monies for the benefit of your children, schooling, education, clothes, things of that nature, till they reach a certain age. And I'm kind of oversimplifying here. And then lastly, there would be irrevocable trust, which really dances upon a lot of asset preservation and our elder law specialists and Medicaid, Medicare concerns that we may have. So really, it just depends on kind of what your objectives may be in designating a trust. But anonymity, confidentiality, certain reasons that we talked about, the different types of trusts, and also tax objectives. There are certain tax objectives, avoiding probate, because as I just mentioned, your will goes to probate, but if you fund those assets through a trust, that would flow outside of your estate, outside of probate, thereby avoiding that process and probate fees theoretically. And then lastly, I would say, depending on the different price threshold or liquidity that you have in the monetary amount of your assets, some seek out different trust planning objectives for that specific purpose, due to those types of requirements. So it really just depends on what you're trying to accomplish. But again, it's a private document. At the end of the day, it's just a contract. It provides an incredible amount of flexibility and planning, and it's confidential. So some people dig that, especially if they don't want things splashed even after their death, in that public record component. But I'll also kind of qualify that to say that I think that trusts, we see in a lot of infomercials, and you're like, those are cool, right? Like, I want a trust. I want one of those leather binders. Like, if you have a trust, you must be somebody. But sometimes we can accomplish your objectives and accomplish your needs based on whatever, your intentions are without doing a trust. So, with us at Pitt and Frank, we're always going to guide you and lay out the education straightforward within our consultations and initial meetings. And we're never just going to say, absolutely, we can do a trust for you if we don't feel like you need one. Okay? We don't want you to spend that unnecessary money unless that's something that aligns with your objectives. Good.
Okay. All right, next up. What key things should I think about when planning for my home? So like where I live, or if I have rental properties, or if I have a vacation property in my will or trust document. So how does the types of properties I own influence what I need to be thinking about?
Jump in. I'm like foaming at the mouth. All right, so I have to start by just saying that when you purchase real estate, there needs to be some thought into how you should title that real estate asset. So we should all know when you buy a car, it's a title to your car, right? When you buy a house, it's called anybody? Deed. Yes, winner over here. Winner. He gets an extra round, bartender. Yes, it's called a deed, okay? So that is the title to your house. So yes, you can take title as an individual, okay? So let's say your name is John Smith, sir. You can take title as John Smith, but she mentioned rental property over here, or maybe even vacation home. So we like to have conversations with our customers relative to what we're trying to accomplish. And with rentals or investments, oftentimes that's limiting liability. So there's that business planning component. Do we need to form an LLC, a limited liability company, whereby if you are renting that, if you are having invitees, if you're having tenants in there, if there are people that could come in and slip and fall and sue you, so to speak, right? Do we want them suing you, John Smith, on deed? Or do we want you, not that we want you sued at all, but do we want them to sue you as John Smith LLC, which means that they would have to sue that LLC, that LLC's assets would be subject to any damages that may be awarded by the court, as opposed to coming after you personally. The whole theory behind that LLC is it provides liability protection for the individual. So there's really thought and planning behind the best way to take title to an asset, and it may not always be your individual name. Even if it's your primary residence, there's thought and consideration relative to, are you in a high profile position? Is that something where, God forbid, you would be in a litigious situation that could come after your personal assets? Do you need to shield that by deeding that in a certain entity or limited liability company? Similarly, you could also title that in a trust. If that asset is something that you want to pass according to that written contract, that trust instrument for the benefit of your beneficiaries, then you would need to fund that and title that on the deed in the name of the trust. So again, important number of considerations depending on what you want to accomplish. But oftentimes the best way to title those rental properties, maybe not in vacation homes, depends if you're renting out while you're not there, would not necessarily be in your individual name, and a lot of people don't realize that. A little bit of an administrative nightmare in the sense that, I think if you form an LLC, there's some incidental costs associated with that, setting it up with the Secretary of State, which we can do, maybe some business law documents. You gotta, file your tax returns and maybe open a bank account and get your EIN. But at the end of the day, that peace of mind, knowing if the worst case scenario happens, you may be shielded by that liability protection, well, that would make me sleep better at night.
Yeah, and I was going to say, if for whatever reason you've already bought a home, those things can be deeded into those instruments as well. So just because you've already purchased a property and it may be in John Smith or whatever the name may be, you can obviously change those over to whatever the plan, requires at that point. So you're not always stuck with whatever you have at the moment. We can move and shift things around if we need to.
And that's called that's called a quit claim deed, okay? So people commonly refer to it as quick, and I'm like, yeah, we're quick. We can draft those pretty quickly, but it's quit, Q-U-I-T, quit claim deed. It is a style of deed where we can very easily change the titling, the deed to your real property, if you do want to place it in the name of your trust, or create an LLC, or add, mom or dad, or add a spouse, or a child, depending on your estate planning objectives, which could be common too. So not to get too far down in the weeds, but I think it's important if we're talking about our bundle of sticks and we're talking about ownership rights and how we title property, to let you know that if you have more than one person on the title to the property on your deed here in the state of Kentucky, the default is tenants in common. Whereas most married couples desire, at least, to take title as joint tenants with rights of survivorship, but that must be indicated as such, okay? It's not the default, right? You have to notate that. Fantastic. Emily says, we've explained the difference. So if you
I said, will you explain?
Oh, absolutely. Yes, that's a will you. Yes, I'm happy to. All right, so Morgan and I buy a property together, and we take title as tenants in common. That means that, God forbid, I die or he dies. I'll be the one that dies.
Sure.
I die, then my interest, my undivided 1/2 interest in that real property doesn't go to Morgan. He's on the deed with me, but we own as tenants in common. So whether by default, because I don't indicate the manner in which we hold title, or I say tenants in common, or the drafter says tenants in common, my share, my undivided 1/2 interest in that property either passes to my beneficiaries under my will, or it goes to my heirs under intestate laws. Conversely, if we hold title as joint tenants with rights of survivorship, which must expressly and implicitly express that on the deed, okay, or a similar variation thereof, joint tenants with rights of survivorship, and it's not just reserved for married couples. It can be for business partners, family members, anything. It doesn't matter. So let's say Morgan and I take title as joint tenants with rights of survivorship, then I die, I'll die again. I came back and I died again. So I get on that soul train and I die again, then that means this time if we hold in survivorship, at my death, automatically my interest goes to Morgan. It is non-probatable. It doesn't matter what my will says, if I have a will, what Kentucky's intestacy laws, if I have a trust, none of that really matters, because we've controlled that real property asset by titling, and therefore it flows outside of probate. It's controlled by survivorship, and automatically at death, ain't nothing have to be filed, done, paid for. It automatically goes to him, and now Morgan owns 100% of that asset. So you can see why married couples, for instance, oftentimes see that as the best case scenario, because that's one less thing they have to worry about whilst they're grieving, one less thing they have to worry about to go through probate. It's gonna come to me, I don't have to worry about the house that I live in, kind of thing, okay? So I think that's important to understand the different manners in which you can hold title.
Very good point, and thank you for explaining that. Okay, so the next question, I think we have touched on it. I just want to give you another opportunity to add, as we like to say at the Price Group, clarity is power. So add some more clarity if you feel like it's warranted, and that is, how do wills and trust actually protect me and my heirs when it comes to real estate? How do they distinctly, with clarity, protect us?
Accurate.
Yeah, I think the main thing, we kind of have touched on this on the periphery. I think the main thing is allowing the person who has passed away in this instance to have control over what happens with their stuff. And again, I think the main thing is avoiding the intestacy laws, and both a will and a trust accomplish those, obviously through different vehicles. But I think that's probably the main thing, is returning control back to the person, divvying up their stuff wherever they want it to go. And I think one other point as well is, I think everyone needs a will. Not everyone needs a trust. So even if you do get a trust, and after we have those conversations, we can kind of determine that, we'll still do a will as well. And there's varying reasons for that, mainly because, like Cora was saying, if you don't title everything into the trust or use it as appropriately as some people should, then we'll have that will piece to catch everything just in case, because if we have a trust but not a will, then intestacy can still kick in. So I think, again, that's the main thing for me, is just returning control to the person and allowing your hard-earned assets to go where you actually want them to.
Add something totally totally unrelated to that. We talk so much about death and dying, or at least I've died twice in this conversation. Might I just add that please don't neglect in our estate planning conversation the important usage of a power of attorney. So a power of attorney is utilized while you're living, and make no mistake, they terminate at death. So once you're dead, we don't worry about powers of attorney. But while you're living, that can be super duper important. God forbid you are in a situation where you're on, life support, or you've had an accident and you're temporarily incapacitated. Maybe you have a young child that's just turned 18 and you're relinquishing them out into the world, and they're going to college in another state. And guess what? Suddenly you as mom or dad don't get the privilege of understanding everything in a doctor's conversation. God forbid something happen. So having that power of attorney, having that even medical power of attorney in place, I don't care how young or old you are, I think really is an important piece of conversation that oftentimes people neglect. It's not just about when you're dead, it also is important to talk about when you're living. And people sometimes do powers of attorney once they start to diminish in capacity. We all have loved ones or family members that are impacted by dementia and Alzheimer's and things of that nature, diminished capacity. But let's talk about those before we get to that place.
That's a very good point. So I'm going to go off script here for just a second. So let's say that we show up in your office and we're like, hey, Cora and Morgan, so I want to go through this whole will process that we talked about. And we're not remembering all these checkpoints that you told us to think through. Is it part of your practice that if we just raise our hand to say, I want to talk about a will, that you would prompt us to talk about the power of attorney and things like that?
It's a package conversation.
Okay.
Yeah, and I think a full estate planning package has a will, a power of attorney. That would probably be both a general, which covers all the financial stuff, and then also a medical one. And then we're also going to talk about healthcare directives, because you want to, it's always, again, death is super morbid, but I think of life as like a timeline, and the POA and the healthcare directive takes care of you while you're still around. And then the will kicks in afterwards. And we don't want to just do this back piece and leave you uncovered while you're still around. I know that there's a lot of people that we deal with who call us and they go, hey, someone's in the hospital, what can we do? More often than not, there is something. They still have some sort of capacity, but sometimes we do have to have tough conversations that, that individual is unable to enter into those contracts and legally sign stuff. So I really think getting stuff now is super important. But we always prompt everybody, and most of the time we're going to end up doing all of it. And very rarely is someone going to decline it for whatever reason. But we'll go through everything, and if there's bits and pieces you want to do or not do, we can obviously kind of go through that and do things or strike things as it may be.
And I'd be remiss if I didn't mention that if you already have these types of tools in place or documents in place, we often review them and may or may not amend them based on different changes in your life, whether you've had additional children, whether there's somebody that you're not favorable towards anymore, or whatever the case may be. And so we oftentimes help walk through that with somebody as far as what their new wishes may be, revise those documents, and sometimes even just revoke those and create new documents if need be. So, don't feel like if you have something that it's a straitjacket or that it's permanent. Oftentimes we'll have, having something is better, but maybe you did a will 30 years ago. Life has changed. You have changed. We oftentimes have those conversations about how we update those documents. Not a problem at all.
Yeah, and I usually tell people, at least every 5 years, get the documents out and read them, because sometimes we'll have people that'll call us and say, I read my will for the first time in 20 years, and golly, it's so different than what I remember doing in the first place. So oftentimes, your life may have not changed that much, but maybe the will wasn't really what you thought it was to begin with. There's definitely people that have opened wills up before and been surprised. So we try to go back and change those if possible.
So if you have minor children and you are putting a will together, what are the things that you need to think about in regards to that?
All right, Mama Bear's gonna jump in because I have 4 kids, all right, on purpose. So anywho, and they're all minors at this point. So 2 important things that you want to think about. First and foremost is the custodial arrangements. So if you and your spouse die simultaneously, or there's a predeceasing, or whatever the case may be, who do you want to have custody over your children? Now, that doesn't necessarily mean the court's going to agree with you, okay? So if there's somebody that's a family member that contests that, that's a whole nother bag. But nonetheless, it's your opportunity to say, this is what I want, and here's why, and that would be admitted. So custody. Secondly, the care, right? So there's that pour over provision in the trust. If you need certain assets to be saved, put in a trust for the benefit of your minor children. And again, certain payouts, you would elect a trustee. Let's say if they needed clothes or educational resources or other reasonable means that would need disbursements for that trust for their care. But then ultimately when they reach a certain age, and it doesn't have to be 18, so many people these days are like, I'm not sure if he should get the money at 18. We need to maybe plan for like 25. And that's okay. We can put in a separate age from which point that trust will ultimately then be distributed to those no longer minor children, but what once was your minor children within your will document itself. So those are kind of the 2 big things.
So I'm going to probably mispronounce the word in this next question. What happens to my property if I don't have a will or trust in place? And the word I feel like I'm going to mispronounce is the help me?
Intestacy.
Intestacy. Those laws. And let's just talk about Kentucky since that's where we are. So can you give us just kind of an overview of if we don't do this, then how does that process look?
Yeah, and you may know the actual laws better than I do as far as the process goes, but basically if someone dies without a will, whatever state you're domiciled in, which is just the fancy lawyer term for where your primary residence is. So if that's Kentucky, it's going to be Kentucky. If it's sunny Florida, wherever it may be, essentially those rules are going to take over. And the judge is going to look at the laws, look what you've got, and they're going to distribute the assets accordingly.
Yeah, happy to jump in here. So, what Morgan said is correct. Wherever you're domiciled or you're a resident of, that's going to cover, and you may open probate there as far as, generally speaking, where your estate will be opened and where your personal property and the disposition of it will be governed. However, real property specifically, which we like real estate here, real property, however, is governed by the state in which it's located. So even if you're a sunny Florida resident, if you own property here in Kentucky, that real property, even if you've opened an estate in Florida, is going to be governed by, if you don't have a will, that's what we're talking about, the intestacy laws within the state of Kentucky. Now, if you've opened an estate in Florida in order to sell the real property over here, should you need to open an estate, I'm getting down in the weeds, you'd open up what's called an ancillary administration. But nonetheless, again, we see that sometimes that process being bifurcated, if you will, as it relates to the real property, which is tied to the state in which it's located and the laws of that state, versus maybe if you're domiciled in a separate state. But let's just say we're all Kentucky residents through and through, in which case, when you die testate, you die with a will. That's a Latin term, much like all the other legal terms. If you die intestate, that means you die without a will, okay? So if you don't listen to anything that we're saying here today and you don't have a will, if you died and you need your loved ones left behind, need to open up probate, need to open up an estate so they could sell your assets. Like, let's talk about your real estate. You own 123 Main Street, and we need to sell that property because you live there, you ain't alive anymore, we need to sell that, maybe we need to pay off some debts, etc. So if you have to open up an intestate estate, a probate estate, where does all the money flow from there? Who are my beneficiaries? Because I can't glean that from a document. I didn't create the will. It's not titled in a trust. I don't know who my beneficiaries are. So what does Kentucky's laws of descent and distribution say? What is our intestacy scheme here? Anybody want to take a gander? Has anybody heard the word dower or curtsy? Anybody? Yeah? Tell me about it, Brad. Yeah? All right. Brad's getting stage fright. So dower oftentimes comes up with real estate and spousal requirements. We're one of 3 states left, I believe it's 3 here in our great nation, that still has the antiquated notion of dower law. But nonetheless, essentially, and I'm paraphrasing, it says that your spouse gets a minimum of 50% of any real property that you own at your death. So we're going to go back to you, John Smith. So if John Smith owns 123 Main Street in his name and he's married, I don't care if the wife is on title or not, automatically at his death, one half of that could go to his spouse. His spouse will be eligible for that one half. Now, it's possible John Smith listened to this podcast, YouTube, or is here in person, even better, and they decided to have a will and they gave everything to their wife. Great, she can get 100%. But, and I'm trying to help you out here, ma'am. But let's say you didn't, and you didn't do a will. At a minimum, your spouse would have 50%. Now the intestacy scheme from there would kind of, it's like an umbrella approach. It would kind of go down then back up. So do you have children? If you don't have children, it's gonna go back up. You've got your spouse, but what about your parents? And I like to hear that. That's probably why I had 4 kids, not really, but it could go up to the parents and make them eligible to receive a distribution there under intestacy laws. Don't have any parents alive, it could go out to your siblings. And that's whenever people start getting sweaty and they're like, I don't know, I got 11 brothers and sisters and there's a few of them that I don't want anything to happen to. I don't want them to get any type of distribution from my estate. So that's why you should control it using your will. Dower has a lot more other aspects or relations as it relates to real estate and different signings and things like that. I won't get too far down in the weeds, but also just fun fact, not that any of you were thinking about this, but that's also Dower's the reason why you cannot disinherit your spouse in the state of Kentucky. Sadly, you can disinherit your children, but you cannot disinherit your spouse because at minimum, by statute, they're allowed a minimum of 50% share. So if you did give them less than 50, whether intentional or unintentional, they can just say, I say thanks for no thanks, I'll renounce your will, or whatever the case may be, I'll take my statutory share.
So even with the will, if you chose not to give anything to your spouse, the state would step in and they would still be eligible.
Well, I mean, the spouse would probably contest it. They would want their 50%. Yeah, I don't know that the state, I don't know that the state, she's asking for a friend, okay? And that, I totally saw you look over your shoulder at this gentleman, but it's okay. No, so I don't know that the state would necessarily advocate or enforce your rights, but you would probably, it sounds like. But getting far, what I didn't mention to say is let's on that umbrella goes down and back up. Let's say there's nobody, and sadly I have people come into my office and there really isn't anybody. There are some people that have no family left. It's talking about the state. Your property, if you don't have any of those in the intestacy scheme, it will escheat to the state, okay? So, try saying that 10 times fast. It will escheat to this. So ultimately the state will get it. If there's nobody and you don't have any family left, the state will get it, okay? So if that's not reason enough to get a will, I don't know what is, okay? But again, generally speaking, when you die intestate, irrespective of whether you're okay or not with that state's scheme, whether they're allocating certain benefits. I mean, you're looking at your spouse right now and you're like, I want more than 50%. Don't you even dare not get a will, okay? And that's fine. But, irrespective of those types of distribution schemes, the speed, the efficiency, the timeliness, the stress, the strain, all of that can be avoided with wills properly drafted. God forbid you pass and you need to sell the real estate with a proper will, open an estate, boom, you can sell it as soon as that estate's open. If you don't have a proper will drafted, doesn't have the power to sell real property, for instance, and or you die without a will, it's not snaps, okay? It's going to take more than that. It creates a more significant delay. There are a lot more hurdles and considerations. There are a lot more monetary considerations. It's just not a smoother process. So again, it goes back to my initial comment of said, estate planning, your will planning, it ain't for you. Just like a funeral, it's for the people you're leaving behind.
So I have one more question until we see what questions everyone else has that I didn't cover. And so my final question is, and again, I think we probably have touched on this, but I'll give you the opportunity to kind of tie a bow around it. How can I set my heirs up in the best way possible when they inherit my property, especially when it comes to taxes and family dynamics?
Yeah, I think family dynamics are always fun. I've got a fun family. Hopefully don't watch the video. But I think the main thing is just having the will in the first place. That can avoid a lot of the infighting. We can also put provisions in there that say, if you try and contest my will, whatever you would have gotten that you're trying to get more of, you get none of it. You can do no contest clauses, and that kind of helps. It doesn't keep people from challenging it, but it can sort of discourage it for people trying to take that step. So really, I think to avoid family dynamics and infighting among siblings and people like that who try to get more than their fair share as you wished, it's really just having it in the first place and making sure that it's very clean, very clear cut. Sally Sue gets 20%, Bob gets 10%, Dave gets nothing, whatever it may be, just to make sure that there's no one trying to get more than they actually want to or more than they should.
Well said. The only other thing I'll add to that is really things we've touched on already as far as just making a smoother process, quicker to sell real estate. Certainly there's tax implications. As Morgan mentioned, you can only control so much. If somebody's going to contest it, they're going to contest it. If you've heard the adage, you don't know your family till you go through inheritance with them, it's true. We've seen the good, bad, and the ugly, and it hurts your heart, to see that. But nonetheless, the best that you can do is to put your wishes there on a piece of paper. And if somebody is gonna try to fight that, fine. You can't control that, and certainly because you'll be 10 feet under. But nonetheless, you can't control that piece. All you can do is speak from your heart, speak your wishes, and hope that they will ultimately be upheld. Now, also it talks back about planning. This is why you shouldn't wait. The longer you wait, you've all seen the stories about somebody on their deathbed making a change to their will or creating one, and then suddenly the children are like, oh, she took advantage of him, they cut us all out. Don't make those kinds of, do the planning well in advance before you face a death sentence or a terminal illness or that moment where you're on your deathbed. Do it in advance, and I think there's less room for a little bit of controversy. And Morgan was spot on as far as trying to prevent against contestation and handling that piece of. But it just like with anything in life, you can only control so much, and people are going to be people. And same thing with your healthcare directives. If your wishes are, I don't want life-sustaining fluids, or I do, or, I want to donate my organs or my eyes, but not my ears, or whatever the case may be. In your living will and healthcare directive, if you put that down, I think there goes something without saying to say, Mom wanted this. It wasn't me. I'm not making the decisions. Mom wanted this, okay? And so that's the best thing you can do at this point, is just putting your expressions and your wishes in those legal documents.